Did.
Something that continues to become front and center as we deal with litigation. We have social media issues that have arisen in litigation just about every year now for the last 3 or 4 years. Electronic discovery continues to grow and continues to be a huge piece of what we are dealing with in employment litigation. And it's really no surprise when you look at the stats of what we're dealing with. Facebook continues to grow. I think the stats right now show it to be about 1 billion users, so 1 in 7 humans on the planet have a Facebook account, which is just staggering. 175 million people use LinkedIn, which is obviously more of a business-oriented profile or platform. There are 119 million active Twitter users. Obviously, we saw a lot of active Twitter usage during the last election and the campaigning. Apple sold 5 million iPhones, 5Ss, in the first 3 days. So, you know, we have, and they're just one of the smartphone providers. We've got 116 million smartphone users in the U.S. So this really is a different type of device now that we see. People carry it with them every day, and it is really a mini computer, and that's a different technological standpoint that employees are coming to the workplace with versus 5-10 years ago. Social networking sites continue to be all the rage. Again, these stats are just, I think, really just astounding in terms of how many folks are using these social media sites on a daily basis. And when you look at the fact that the average American spends about 3 hours per day on social networking sites, you know that some of that time has to be occurring in the workplace, which is part of how we get to some of the issues that we're going to talk about today. Employers are using social media to recruit, to screen candidates. We're going to talk about some of the pitfalls in a little bit that arise with some of that usage. You know, and they're using it, I mean, employers are using it for good reasons, to engage candidates, to close deals, but unfortunately with that comes some risk, and we're going to explore some of those issues. So what are you likely to find when you go to a social networking site, when you type in an employee or an applicant's name? Well, you're going to find stuff certainly that could be useful when you're interviewing a candidate, or maybe you're looking to promote someone, things like education history, work history, career interests, hobbies, memberships, but you may find other things that will start to trigger issues under various federal employment law statutes, things like drug use or former drug use, former alcoholism, poor judgment in general. That doesn't necessarily mean it's protected, but we may learn things that we perhaps wish we didn't know. Vacation photos, party photos, family information, links to profiles of friends or blogs, political views. So these are all things, and unfortunately you get the good with the bad when you are using social networking sites to vet candidates or to vet employees and see what they're engaged in. So what if a rejected applicant, someone applied for a job, didn't get the job, and let's say that they didn't get the job because maybe they didn't interview well, and that was really the reason why. We thought maybe perhaps they didn't have the requisite skill set. But as part of that, you know, interview process, let's say we also looked at social media sites and we learned some of these things. You know, someone's religion, someone's union affiliation, someone's age, whether or not someone has a disability, their military status or veteran status, whether they're pregnant or not, or their family status. So these are all things that are protected statuses or protected categories under a variety of federal statutes, things like Title VII, USERRA, the National Labor Relations Act, the Americans with Disabilities Act, the Age Discrimination and Employment Act, all things that are protected categories, and not necessarily things that you went looking for, but you could very easily learn or see, and you cannot unlearn. And the problem becomes if you then reject an applicant and they can tell or see or learn that you have identified or seen this information on them, it's logical for them to believe or feel that that played a role perhaps in the decision not to hire them, and you're immediately going to be put on the defensive to defend why you rejected that applicant, that it had nothing to do with any of these protected categories. Again, same thing with sexuality, gender orientation, someone who likes to party a lot, someone's political views, someone's, you know, partying habits perhaps, you know, or just generally whatever hobbies or interests they may have that could lead to particular stereotypes, etc. So a lot of times, when employers are interviewed and they are asked why they didn't give a candidate the job after they reviewed a social networking site, 50% of those employers who were surveyed, I think who are being honest, attributed the decision not to hire to things like provocative photos, references to drinking and drug use, bad-mouthing of previous employers and colleagues. Now, those are all things that are not necessarily protected. So, that might be okay. But again, you're going to get the good with the bad. You're not going to be able to screen out those things that you wish you hadn't seen to necessarily find some of these things. So can we decide legally not to hire someone who's, we've reviewed on social networking and we've learned stuff about? Generally, the answer is yes, as long as we're not violating other federal or state discrimination laws that prohibit using that certain type of information. There's no prohibition against using information that's publicly available. However, you do have to be, like I said, concerned about learning those things that you can't undo. People's race, gender, national origin, age, pregnancy, etc., all protected categories and things that cause a risk if we've looked at those or incorporated those in any way, shape, or form into our decision not to hire. So what are some hiring issues that can arise? We know they can trigger these anti-discrimination statutes. And we can end up with access to information on protected statuses that we probably otherwise would never know. I mean, let's assume that, your interviewing process is tight, you're doing interviewing screens and questions that are formatted very carefully, you're asking all candidates the same questions, and everything in the actual interview process is good. The application is good. It's when you actually go onto these sites and you start learning this other information that you maybe otherwise wouldn't have known. I mean, like maybe we wouldn't have known someone was 3 months pregnant. Maybe they didn't show when they came to the interview. It otherwise would not have played a role, but we do a social media search and we realize that someone has indeed just announced to family and friends that they are pregnant. And we then choose not to hire them. And maybe it's for that reason, maybe it's not, but it could be problematic. An example of a case where this went wrong was Neiman versus Grange Mutual Casualty, where a failure to hire involved an age discrimination claim based on a college graduation date that had been posted on LinkedIn. And there was a retaliation claim because the public records, were disclosed, as a result. He then sued his employer, his prior employer. So there were lots of different pieces here, but that's typical of what we have started to see. We've started to see a larger trend towards employees questioning why they didn't get the position. And that triggers not just a need to make sure we're careful with social media, but to also make sure that we're obviously being really careful in the interviewing process. We've got documented responses to questions. We've got our, clear notes about maybe how someone presented, maybe how people articulated responses to questions, things that they may have said that turned us off in that interviewing process or in the application process, so that we can articulate that it's these things that were the issue or the deciding factors, as opposed to other protected categories, whether we learned about them on social media or otherwise. We can learn too when we're on the web about someone's workers' comp history, their criminal or arrest histories. Again, all things that, to some extent we may be able to consider, for example, criminal convictions for felonies, but arrests are certainly not things we can consider. Someone's workers' comp history is not something we can consider, but certainly are things that we may find out just generally looking online. In November of 2013, the Wall Street Journal reported that there is extensive use of fake resumes and profiles. Between 10% and a third of employers searched websites and social media sites for information early on in the hiring process, and that's part of how they I think, were learning about some of the usage of these fake resumes and profiles. In those cases, though, part of what the Carnegie Mellon University looked at when they were doing this study that the Wall Street Journal reported on, they did a blind profile search, and they had cases or hypos where applicants were Muslim, and once that was revealed in the interview process or earlier through social media, those candidates, they found employers were less likely to call them back for interviews. So that's just an example, I think, of how the information could impact employers even unknowingly, or even unintentionally, and perhaps just even the stats alone could be problematic for the employer in such a situation. So what do you do? What do you do when you've got these searches? What can you do? How can we use them? One way to use the information or to do these searches to verify what people have put in applications and resumes, their involvement in the community, their involvement in trade groups or whatever else it might be, their involvement on boards, et cetera, legitimate information that we may want to verify on applications and in the interview process. Well, you can designate a non-decision maker to conduct the search and filter out any information that is protected information, and that might be somebody in the HR group. If you've got if you're with an employer that is large enough to have its own dedicated HR group, you could have perhaps maybe a generalist, maybe someone lower down, not necessarily the director who might get involved in the hiring process, but maybe someone who typically might stay out, filter out that information, but is someone who obviously has enough background in education to identify what protected categories are, or train someone to be a non-decision maker who can conduct these searches and search, and filter out this protected information. You can, make sure you're only disclosing information that's job related. That is, can they write sentences? Have they been, consistent in the information they've provided to us, et cetera. And think of other ways too. I mean, there's where it becomes dangerous is when the hiring supervisor is out there doing their own searches without any guidance just because they can Google someone, and they do. And they're usually not as trained as executive management teams or, as trained as HR obviously is. And they don't know that there are things that they shouldn't be looking at. And a lot of times they're the ones that are going to be revealing that they have looked at this information, and they're going to be revealing, obviously, protected categories through that interviewing process. So some of this, too, obviously, is training. I think you want to make sure that if you are using this, that you're letting your folks know how it can be used, what can't be considered, and some of these other things we're going to talk about, too, in a few minutes, like security and the proper way to access information. All right, so what should you do? I mean, obviously, some of this information, too, requires us to get past, security tools. Many states have passed or activated statutes that do not allow employers to either request security passwords or codes to, access this information, or otherwise prohibit employers from illegally or unlawfully accessing the information. So you do have to make sure that when you are accessing information, you're only accessing information that you lawfully have a right to access. That is that which is publicly available. You don't want to use any kind of false identities or false passwords or requiring of passwords or usernames to get access to this information. That absolutely is fodder for trouble. Virginia is one of the states that has passed a statute that says we're not allowed to ask for this information, and obviously, conversely, we're not allowed to get it illegally. And so, you have to also think twice, I think, with these types of protections in place, do we want to even ask, coworkers or other employees within the organization who may be friends, let's say, with an individual on Facebook to access that information and then provide it to us. Again, I think that can be fraught with issues as well. So I really do think that employers who are using this should stick with that which is publicly available and stay away from anything that's going to be security protected. So, before you begin to do any kind of a search, certainly individuals that will be doing these searches need to understand what is the relevant information to the job before they even begin the search. And then how are we going to go about doing these searches so that we have some consistency. If you're going to only search individuals that you have concerns of post-interview and not everybody you interviewed, well, that could be a subsequent claim of discrimination, right? That we only did these searches on the 4 female candidates that came through. We didn't search on any of the male candidates, and you can kind of see how that would play out. So doing them consistently, identifying the information that we're going to deem to be relevant that would be considered, making sure that we know who the person is that's going to be doing these searches and that they've had the training, documenting what we find, right? Because an employee, if they believe that you found something that you used that was available, that you searched and found on them, they may think that it's something that you're not even aware of. So again, documenting what you found and whether or not you considered it, whether or or not it was relevant is, again, going to be useful information that we're going to want to have should we be challenged later on for a reason why we didn't hire or why we didn't promote. So should we ask for passwords? I covered this already a little bit. Absolutely not. You can see that at least 21 states have already enacted statutes that protect individuals from having their password requested. And it's not just whether or not these individuals are coming to a job, let's say in Virginia. If you're hiring an individual, let's say out of Denver, and you would ask them whether or not they will, if they'll give you the password so you can do these searches, well, it's illegal in Colorado to ask for such information. So even though you may be hiring them into a state where maybe those protections don't exist, if you're hiring them where they currently live and they do have those protections, that's where you're going to get sued. And obviously that's where you're going to end up having some concerns on violation of those state statutes. So I really don't think you should be doing it. And that list continues to grow. I suspect post-election, I think it did not get a chance to update it, but I suspect the numbers are already higher than 21. So, you know, at least half the states roughly are already having those statutes in place. Employees, though, should be aware, and let's switch from social media usage when you're interviewing or screening applicants or promoting someone to employees' usage in the workplace. Certainly, as an employer, we do have rights in the workplace when employees use social media, especially when it's on our computer or company equipment. We want to make sure that our handbooks have in them statements that disabuse employees on expectation of privacy. And it's not just for social media usage, it's really for everything, right? If an employee leaves us and we think they took customers or we think they violated a non-compete or a non-solicitation, well, we're going to go search their email. We may even do it while they're still there. Again, another reason why you need to have that no expectation of privacy so that employees know and understand, hey, that's our email to the system and our server, that's our computer you're using, even though it may have a password on it, and it's our systems, and we will reserve the right to search and look through that information whenever we want. Adequate privacy policies where you're disabusing employees properly have been upheld. There have been cases recently even where employees were writing their lawyer about lawsuits, employment lawsuits, and employees tried to claim, well, that was privileged attorney-client information, and courts have held, no, it's not, because you used the company's computer to do that, and you used their email to do that, and they told you that they would look at that information. And so you've lost your rights to confidentiality. So again, you want to make sure you have that policy in place. You want to make sure employees are aware of it and that they know that they're supposed to abide by our non-disclosure and confidentiality agreements. Certainly that's a reason why they shouldn't be disseminating information like this on electronic platforms. You know, we also want to make sure too that when we're talking about social media policies, and we're going to talk a little bit more in depth about those and how the National Labor Relations Board has started to attack social media policies. But we also, in addition to the expectations of privacy, we want to make sure employees understand what they can and can't do when they're in social media, right? So it's not just this expectation of privacy and how they can physically use the equipment, it's speaking on behalf of the company, and we want to make sure that we have a social media policy that addresses that. We have a media policy in general that addresses whether or not individuals can speak on behalf of the company, and if they're not speaking on behalf of the company, you know, we can't necessarily tell them they can't speak outside of work hours mentioning the company, but we want to make sure they're identifying perhaps that they're employed by the company or that this represents their personal beliefs and has nothing to do with their employment with the company, et cetera. So those are all things we're going to want to make sure we're updating and looking at our policies for to make sure they're current and up to date. Obviously, social media, a huge source of litigation for us right now is how social media is being used to further or to commit harassment or discrimination in the workplace. Many harassment discrimination claims involve electronic communication. Gone are the days where people used to post a note or leave a piece of paper in someone's chair or the calendar with the you know, scantily clad individuals in it up in the break room. That's not really what we're litigating anymore. We're litigating harassment discrimination claims that involve emails, texts, sex, you know, voicemails even that have been left. And those are electronic records that unfortunately never really disappear, right? it's very difficult to delete those. It's not as simple as just throwing away a paper in a trash can. It leaves an electronic trail, and it does complicate the litigation. And we want to make sure, too, that we have policies that are comprehensive enough that address these harassment discrimination concerns in social media, in email systems, in phones that are company issued, et cetera, any electronic device, because we do have an obligation to eradicate hostile work environments even when they occur outside of work. So someone perhaps posting to social media, let's say an employee complained about someone else's behavior, found it to be harassing or discriminatory, HR launches an investigation, and the employee chooses to, who's being investigated, chooses to go and post something online about how this is ridiculous and has various expletives to identify the individual who's complained, furthering the harassment or discrimination and possibly even retaliation against this individual. Yeah, that then becomes the employer's business, unfortunately. The electronic platforms, the social media platforms have become very much like comments that were made after work at the bar while people are having a glass of beer. And it has extended the footprint of what employers have to be responsible for and what their policies have to anticipate and cover. So again, and managers and supervisors, I mean, here's another big one. You'd think it would be really easy for managers and supervisors to understand they should not be friends with subordinates or direct reports in social media. They should not post stuff about work or about investigations or anything else that's really going on that would otherwise be considered privileged and a no-no and stuff that they shouldn't be talking about in the workplace. A lot of times managers and supervisors have lapses and they post it in social media. They think that is okay. And I think certainly too, to the extent we continue to have younger generations move through the ranks and become managers and supervisors, their perception of what is appropriate to be shared, I think, is different than other folks who may have preceded them in that role. And again, it's different generations, different perceptions, and I think policies need to take that into account. Training needs to take that into account. You need to make sure that everybody understands the liability that an employer has, the large footprint that it's responsible for making sure that it's policing for hostile work environment, harassment, discrimination claims, etc., and very directly engaging managers and supervisors on what they should and shouldn't be doing, because that is direct liability. So not only do we have this responsibility with regards to other employees and what they're doing, these managers and supervisors give us direct responsibility and liability, and that's even more expensive should they misstep or not follow our policies. So I really do think that if your EEO training, your equal employment opportunity and harassment discrimination training that you should be doing on an annual basis doesn't talk about this component, most employers have really missed the mark, because we are seeing it in just about every piece of litigation that we engage in and defend companies on right now. So what about disciplining employees, taking disciplinary action or termination decisions based on what has been posted? This is a common question. I just did a presentation last week, and someone in the audience on a break said, hey, I just learned that an employee posted something on Facebook speaking really negatively about a manager and a supervisor and a decision that had been recently made, and I want to discipline them because they really, they used words perhaps that were not appropriate. I know they were complaining, but it wasn't, we don't feel it was the right way to go about it. And I get where the employee is coming from. I get where the employer is coming from. And typically the answer is yes, we may be able to take some disciplinary actions up to and including termination, as long as, though, it doesn't violate other discrimination or employment laws. And that's really a big, huge caveat for us right now. Maybe things will change under the new administration post-January, but certainly under the Obama administration, we saw a very aggressive National Labor Relations Board. We saw them come after employers very consistently and significantly for disciplining employees who have posted thoughts or articulated speech in social media platforms that they believe was protected concerted activity under the National Labor Relations Act. So those are all things we need to keep in mind. In addition, when we're looking at this information, one of the first things I ask when an employer calls me with this type of issue is, how did we get the information? Was this a public post? Did we get it privately? Did an employee bring it to us? Because if it was the manager or supervisor out there gunning for an employee and they accessed information unlawfully, we can't use that. That's not going to be something we can use. And in fact, maybe now the manager or supervisor needs to be disciplined for accessing information and compromising the business because they perhaps, falsely used someone's password. Or pretended to be a friend of the employee, using that friend's username and password to see the information. That's all going to be illegal versus information that was legally provided to us. I mean, an employee who's concerned about a post or doesn't like something that has been sent, who prints it out or screenshots it and sends it to a manager or supervisor or to HR, okay, well that may be fairly considered, and courts have upheld that. Again, are we searching consistently? Have we singled somebody out? Is the source reputable? Is it something that could later turn into defamation or, some other kind of slander claim? So we do have to be careful about how we got the information and where it's coming from. Some states, certainly when we're dealing with information that we're looking at online, some states have said, well, you can't discipline or terminate someone for lawful activity, as they call it, even if it was off premises or during non-working hours, and we know that the employee may represent you, or you may feel that they represent the employer even in those non-working hours. Well, you can't necessarily discipline them or terminate them for what they call lawful activity. And there are some states that have really sweeping broad statutes. Some have a little more constrained statutes. But you really do, again, you have to be careful about where the employee is, where the action was alleged to have occurred. Are there these other rights? Now, Virginia is not among these states that gives this type of protection. But like for California, for instance, I can't, as an employer in California, discipline an employee or take, any kind of adverse employment action against them for posting a photo of them drinking at a beer festival on the weekend. That's lawful. As long as they're over the age of 21, they're lawfully able to drink beer, and they're able to do it in that public setting. And the fact that they've got 4 beers in their hand and they're, slamming them back, well, that's not something I'm going to be able to really do a whole lot with as a California employer. California also protects public, commentaries on political affiliations, etc. So those are the types of laws you have to be concerned about. So in terms of disciplining, as I mentioned, we really have to make sure we're abiding by federal and state employment statutes when we're deciding whether or not we can discipline an employee or terminate them for particular social networking activity that they've engaged in. So certainly we want to make sure whether before we decide what might be appropriate in line with the statutes, part of it too is we want to look at how the employee approached this. Did they intend to try and keep this internet activity private? We want to make sure we're not using a false identity. We want to make sure too that we're not friending subordinates, etc., because if that's how we learn the information, it may be something that is also equally inappropriate on the part of the manager or the supervisor. When did this happen? Did it happen during work? Was it a post during work, clearly at 10 o'clock in the morning when the employee should have been working, or was it something that was said when they were at home? Because again, I think all of those things are factors we need to take into consideration, because employees' concerns need to be balanced with employer concerns. Obviously employees have concerns for privacy, political activity, lawful activities, collective bargaining rights under the NLRA. Whistleblower protection has even begun to start to encompass these types of activities, in litigation. It's been expanded to include that. And employers are obviously trying to balance those concerns of the employee against concerns that are legitimate, like harassment, discrimination, interfering with job functions and workplace productivity, protecting confidential trade secret information that an employee may be revealing through their social media posts, negligent hire, negligent retention, right? If we learn that an employee is continuing to drink heavily on the weekends and then showing up, in the company car on Monday morning, and we've already gotten some concerns or complaints that they may be under the influence, and now it's corroborated with media posts from the weekend that perhaps they overindulged, well, that might be problematic, because then if they get into an accident, it could expose us to a negligent hire, negligent retention claim. So all of these, it's become a very difficult balancing act for us, and the National Labor Relations Board hasn't really helped us in that regard. They've heavily weighted the NLRA in its interpretation of it to protect employees that are engaging in what they call these concerted protected activities of speech in these public forums. And it's unlawful for an employer to interfere with, restrain, or coerce, or otherwise chill an employee's exercise of these rights. In addition, we can't threaten them because that could be considered retaliatory if they want to engage in that type of activity. So, the NLRB very early on under the Obama administration, and again, I'm going to say this is the current state of the law, this is where we are now. This could do a complete 180 come January, and it's likely that it probably will, because the NLRB is an agency that is very heavily subject to the whim of the current administration. The board appointees are just that, they're appointees by the president, and the NLRB is an agency that historically over the years, you'll see it periodically with every administration switch, do 180s on their case law. And I don't think this is really any different, because this was such an aggressive posture that was taken by the NLRB. But let's just talk about some of the stuff, and you'll see why I really do think it was a very aggressive, assertive posture, and I do think it's ripe and highlighted for some change. They found that a Facebook post where someone was soliciting assistance from coworkers on how to deal with a job performance issue with their boss was considered protected activity. Well, okay, I guess I could probably see that. And they said, obviously that was protected, but even when the employees started to swear and use sarcasm and demeaning comments about the supervisor, but that didn't cross the line. The employee was still engaged in what they called protected concerted activity, and I think that's really what's most difficult for employers to understand. I'm going to give you some more sample cases. So there was a violation, of the NLRA where an employer terminated employees for engaging in a Facebook discussion criticizing their employer's failure to withhold the proper amount of state income tax from paychecks, including, again, use of profanity. But the NLRB said that was protected concerted speech, and they obviously were doing mutual support was the primary purpose, not to engage in disparagement. Even clicking just on like in Facebook, for example, can be considered engaging in protected concerted activity. That simple function of hitting the like button. They've found that they've really gone after social networking policies and found that those that are overly broad, that have threatened to discipline for things like publicly sharing information where it's not really very limited or well-defined, was too broad and violative of the NLRA. So again, something that you have to look at when you're drafting these policies. Social media policies that contained an insubordination rule was, again, found to be overly broad because they didn't define the terms, and therefore because it wasn't clear what would be considered insubordination, it had a chilling effect on employee rights. There's another case that came out fairly recently where, an employer said that you can't make disparaging or defamatory comments about the company, its employees, officers, directors, vendors, partners, affiliates, or their products and services, and that you needed to use good judgment. It sounds fair, right? I mean, the employer is just trying to make sure that they protect the employees and protect the company here, and disparaging and defamatory comments seems to be at a pretty high level, right? And reminding people just to use good judgment. Sounds like it would be a lawful policy, right? Even there, the NLRB said that was unlawful because nothing was really defined there again. So you can see, I think, where the Obama administration's NLRB was on a lot of these issues. I do think that this is something we're going to see a lot of change on, mostly because it's been really difficult for employers to comply with this very drastically, quickly changing landscape from the NLRB in terms of how they interpret the NLRA. It's become very, very difficult. I mean, even as an employment attorney and even in a firm that does nothing but labor and employment law, I mean, we have a group and we update our, interpretations, our compilation of what has been coming out from the NLRB in the last 8 years. And that compilation has been difficult for even us to keep up with, because that's how we draft our handbooks. It's how we're modifying policies to try and stay ahead of what the NLRB is interpreting interpreting to make sure people stay in compliance. And even that's been very difficult in an uphill battle. So I do think that a lot of this is going to change, but unfortunately, it is still currently in a state of the law. And I think even if the NLRB changes their stance, has some new board appointees, and they do a 180 on this stuff, I still do think, though, that many employees have become very educated on their rights as it regards social media usage and employers' inquiries into the same. And I think for that piece of it is not going to disappear from employment litigation. I think employees have become sophisticated enough to know what those rights are, and I think hold dearly their ability to engage in social media usage. And so I think that's going to continue to happen. So I still think it is prudent, though, for employers to get ahead of these issues and have policies and have training that take on these items. All right, an employer rule is under the current board is going to be found unlawful with regards to social media where it explicitly restricts protected concerted activity or where the employee could reasonably construe the language to do that. If the rule is promulgated in response to union activity, and if it has been applied to restrict protected concerted activity, that's going to be problematic. So things that you need to ask yourself when you're looking at your policies for social media, if you're looking to be in compliance with the National Labor Relations Act, and before you discipline for a social media post, you want to look and see, did it seek to initiate, induce, or prepare group action? Because if it did, chances are it's protected concerted activity under the NLRA. Does it reference conversations with coworkers that occurred before postings were made so that the posting is a logical outgrowth or a follow-up to those conversations? Again, if it did, it's a conversation amongst one or more employees regarding protected concerted activity in the workplace. It's going to be protected. Did it seek to bring a group of complaints to the attention of management or even one employee's complaints to the attention of management? I had an EEOC charge a couple of years ago where the manager was unfortunately friends with many of his subordinates, and it was a natural attrition. He had risen from the ranks, he'd become a manager, and I think nobody had really sat down with him and said, hey, now that you're a manager, now that you speak on behalf of the company, it's not really a good idea for you to continue to be friends with your subordinates. They really don't need to know what you're doing on the weekends and in your off time, and you really don't want to know what they're doing in their off time. And sure enough, this guy had an employee that had been complaining and had not really been addressing it or dealing with it in the workplace, and the employee resorted to social media to reach out and talk to management, talk to this guy about the complaints and the issues. He then defriended her and said, please stop, writing to me in social media. If you have a complaint, you need to come to me in the workplace. And, again, the court, in looking at that, it was not in the context of the National Labor Relations Act. It was strictly a Title VII claim. And the court there looked at it and said, well, it could be retaliation that this guy defriended this individual because, that, shut her down. I mean, she made this public post. She sent this message. It wasn't a private message to her manager asking and complaining about certain items, and he doesn't respond and he defriends her. And, that could have been viewed as retaliation and certainly was an extension of the employer's Title VII harassment discrimination policy and whether or not it was effective or ineffective in dealing with these types of issues in the workplace. And honestly, I don't think that employer ever anticipated or intended that it would have such broad reach, but I think you've got to. If you're not, and you're being short-sighted, I think, in the current technology framework that we're working in. So other questions to ask, did it result in any coworker responding to the online post? If so, then those individuals may also be shielded in protection from whatever statutes at issue, whether it's the NLRA or Title VII. They've become involved in that process, and that can be as simple as liking, right? It doesn't have to be a written response. It can be a like. Or an emoji, I guess. I haven't seen a case on emojis, but I guess it could probably include emojis. Does it reference, involve, or concern wages, hours, benefits, or working conditions? If so, it probably could be protected speech. You could have an issue disciplining on it. So is it so outrageous, disloyal, or disparaging of a company's product or service to lose protection of the Act? And that's true, too, with regards to Title VII and these other statutes. And these are all really good questions to ask, not just with regards to the National Labor Relations Act, but really with regards to any of the postings that we are dealing with when we're looking at what employees and managers and supervisors are doing. So, is this a protected post, or was a post where the associate director is such a nasty and, lots of ampersands, who doesn't know how to talk to people, and it continued on and then closed with vote yes for the union? This is one where the NLRB said, yes, this is protected speech, because in that particular work environment, when you looked at the context of what was going on at work versus the context of the post or the social media statement, the NLRB found that the employer's workplace was so permeated with hostile and offensive language that was tolerated and that was okay in the norm, and that therefore that post that contained similar offensive language was really watered down or diluted, because that is what was going on in the workplace as well. So therefore it was consistent, it was protected speech. So a lot of employers swung the other way in response to the NLRB and said, okay, we're going to just ban social media entirely, that employees cannot use that to communicate about the company. And that's overly broad as well. The NLRB has come after those types of policies and said they violate the NLRA, and they violate arguably other statutes as well. I mean, Title VII carries with it the right to make complaints about harassment or discrimination in the workplace by telling employees that they can't talk about the company at all, whether it's with regards to protected concerted activities such as, hey, it's not fair that they're making us work the next 6 Saturdays in a row, or if it's really someone complaining like, hey, this new supervisor really weirds me out and I don't like the comments they're making and I don't think they're fair and I think he doesn't like women, again, that can be considered protected speech under Title VII. And so restricting employees from mentioning the company at all on social media is overly broad under many of these statutes interpretation. They're allowed to use social media in off-work time. I mean, if it's during work time, that's something where we have a stake in, because obviously we're compensating them and paying them to be working. But when they're at home and they're not on duty and not on the clock, they get to write what they want, especially if it rises to the level of protected speech. Now, that all said, we're obviously balancing that against, is it a violation of another statute? Now, if someone is posting harassing or discriminating comments online, and they're directing those to our employees, then that would be a violation of our harassment discrimination statute and may require us to intercede and act. So, you got to be looking at the nature of it. You're balancing what's going on. So what are key elements that you want to make sure you have in these electronic communications policies? You want to prohibit the use of company equipment and prohibit the, engaging in social media on work time. That's an easy one. That goes to productivity. And we want to make sure that we address what we want employees to be doing. You may even be able to work with IT to prohibit access to certain sites if they're going through the server at work, because obviously people don't want to pay for data. So a lot of these folks are doing it on your servers through your free internet access. And so that's one way to easily kind of control that usage outside of the work network. You want to make sure that you are prohibiting and protecting your copyrighted trade secret material, that you're addressing that in your policies, that we are prohibiting the use of vulgar or obscene language. That is something that's still not protected, again, unless you're the workplace that allows that to happen on a frequent basis. And if you are, perhaps you want to change that culture anyway. You can prohibit promoting company products without a disclaimer, because then that starts to run afoul of other marketing statutes, etc. The employee, if they're touting our products, touting our services, they do have to disclaim that they are a current employee, and you want to make sure you have that language in there. Prohibit LinkedIn recommendations. Here's one. I mean, you may not have even thought about this, but I've actually seen EEOC charges where an employee was told they were terminated because of poor performance, and they were replaced by somebody who was younger, so it was an age claim. And the employee's number one piece of evidence that obviously it was a lie, that they weren't terminated for performance, that their performance had to have been good, was because when the employee left and asked for recommendations, even though when the future employer called in and was routed back to HR, they just got name, rank, and serial number. When one of the future employers reached out directly to the supervisor via LinkedIn, the supervisor gave LinkedIn recommendations to this prior employee. And so the employee's interpretation, and I think it's a fair one to be be warned of was that, well, if I was terminated for performance, why did they give me glowing recommendations on LinkedIn? And a lot of supervisors and managers don't even think about that, right? They're automatically clicking the recommendation, not even thinking about the consequences, or they're just trying to be nice, or they view it as rude if they don't respond. So you need to make sure you're addressing that in training, you're addressing that in policies with your managers and supervisors, because it could be running an end run around your referral policy that you otherwise have in place. Don't prohibit lawful off-duty use of social media. Make sure that your employees are aware of your policies, that they're acknowledging those in either handbook receipts or addendums that you may be issuing. And you want to make sure, too, that you at least do have a Section 7 disclaimer in there about the National Labor Relations Act that says that obviously to the extent these policies are interpreted or found to be violative of the NLRA, that obviously we're intending them to be interpreted to be in compliance with the NLRA. That's not going to be a fail-safe entirely. The NLRB has started to chip away at those types of disclaimers, but at least it's still better than having nothing. All right, so email and computer equipment, that's all the stuff, obviously, that is the property of the company, and we want to make sure we're espousing that it be used for business purposes. A lot of employers will say that if you use company property, including email and computer equipment for non-business purposes, that you'll be subject to disciplinary action up to and including termination. I encourage you to take a look at that policy and look at it in reality and see whether or not that truly is what you're doing, because I think most companies do allow some limited usage, and rather than having a policy that ineffectively articulates that you can't use it at all, I really encourage you to look at it and determine how employees and employers are really using that information and making your policy reflective of that. The NLRB has also said that you must permit employees who've otherwise been provided access to email systems for private usage to allow them to use it for union and organizational campaigns as well. So that's, again, another reason to look at how you're really letting employees use this. It's the same old solicitation distribution statute that we've always been dealing with. If you let people post stuff about, their Girl Scouts, their church, their rummage sale, whatever it might be, on the lunchroom bulletin board, then hey, the union gets to post stuff up on your bulletin board as well. And the email has been interpreted to be the modern day bulletin board. So you got to look at how you're really letting employees use this. And so you're going to, your better tactic may be to limit the personal usage to make sure it's not excessive and that it doesn't occur during non-working time, versus saying, prohibitively across the board, we don't allow any non-business use, because 99% of the time when I go into these cases in litigation, I find that employers are indeed allowing some usage for personal reasons. You have to, right? I mean, how else are you going to be able to confirm your doctor's appointment tomorrow, because it's got to come to an email, and you need to be able to do that during business hours. Where's your kid's school going to email you if they have an issue and they need to reach out to you during the day? So again, I just encourage you to be very practical and encompass all of that as you take a look at your policies. I do want to chat briefly with you guys about bringing your own device to work. BYOD, it's not BYOB, it's not the fun bring your own beer, it's bring your own device to work. Many employers are allowing employees to bring smartphones and iPads and all kinds of other devices into the workplace and to start letting them have access to exchanges and servers so that they can access email when they're traveling, when they're at home, or whatever it might be. And it doesn't just bring with it social media liability, it brings with it, Fair Labor Standards Act issues. Are we allowing people to now work off the clock if they're non-exempt because they have access to their email 24/7, and it's not just having to log into a computer through Citrix? They can actually just access it on their smart device. If these employees are using these devices to perform work for you, you have to have some kind of policy in place. Many times these devices become what we call in employment law dual-use devices. They now have both personal and company data and activity on them, and you really have to proactively start thinking about how How are you going to handle that? How are you going to handle it when the employee exits? How are you going to handle it if there is a lawsuit and you have to preserve information because it's not our device, it's not our carrier, we have limited access to the information? Do you have an agreement in place where you can check that phone when the employee leaves to make sure that they don't have confidential trade secret information? These are all things that if you don't have them in place, you have to start thinking about it. I think BYOD just kind of naturally evolved, and I think most employers just really didn't think anything of it. They allowed the access, and they didn't proactively get ahead of it with a policy that defines where the employer wants to be on these things. And I'm seeing litigation happen where, you know, the alleged discrimination or harassment happened via text or happened via instant message, and it's on a phone and it's not on the computer, and, you know, we're obligated to preserve it because now someone has sued, but I don't even have access to the phone. I'm at the mercy of asking the employee whose phone it is, hey, can I look at your phone? And I'm at their mercy that they've actually preserved it and they haven't deleted it, and it puts you in a really awkward spot. So you really need to start getting ahead of bring your own device and make sure that you've got policies. I really don't think employers are going to have a choice in whether or not employees are bringing in their own device. I think, you know, just based on how fast technology is changing, I've seen a lot of employers not be able to continue to provide cell phones as quickly and as frequently with the changes that their employees are demanding. So it's almost easier for them to say, well, hey, if you want the new phone, you go get it and we'll let you hook into our system. It's part of recruiting, right? I mean, being allowed to bring your device in, like again, saying having a practical approach to what you really are allowing employees to access. Part of that's going to impact your ability to recruit and your ability to retain. Smartphones and tablets are replacing traditional PCs, and it's what people are using, so they're investing in some pretty powerful portable devices, and those are coming into your workplace. You know, cost savings, many employers are doing it because it is cost effective to let employees bring their own device. But you've got to balance that again when you're looking at the overall cost savings against your security, your reimbursement. If you've got other issues going on there, are you working with IT to make sure that they're not compromising your system? What are you going to do if an employee travels and has access to information that's confidential and trade secret? There was a case involving an HR director who had access to a whole bunch of information via his iPad, and including payroll increases for the year, which happened to include Social Security information. And the iPad was stolen from the airport. And unfortunately, it didn't have all of the security protocol in place because it wasn't a company-issued PC or laptop. It was just an iPad. And so that caused liability for the employer. The employer was found to have liability because they didn't take sufficient security protocol to make sure that that stuff wasn't on there, or that it could be turned off remotely or scrubbed, et cetera, like with a PC, if indeed someone had stolen it. So again, those are just all things. We're just kind of hitting the tip of the iceberg. I know we have about 5 minutes left, so I just want to make sure we talk and introduce some of these topics to you so you start thinking about them. You know, risks and challenges, you know, like I said, the data stored on mobile personal devices is not all owned by the company, but it may include stuff that we really obviously care very much about: corporate information, trade secrets, personal information of employees or customers. It does put the company at risk for malicious software attacks, personal information being stolen. Unsecured network usage, lost or stolen devices, family and friends even accessing that type of information, data breaches just in general. So again, you want to make sure you're comprehensively taking a look at all of this. You know, as I said, how does this occur? Someone steals the information, someone inadvertently, you know, hits reply all, which is very easy on a BYOD. I mean, you're looking at, I mean, even with a, you know, a plus size iPhone, which my husband calls lovingly my gigantophone, you know, it's still very easy to hit reply all because the screen is so small. Remote access, wireless networks, all this stuff causes potential security issues. So how do you respond? I mean, initial steps, you want to make sure you're identifying people who engage in this information, who's using it, how are they using it, what are the applicable laws that we maybe need to take into effect and balance against BYOD devices coming into the workplace. If things are stolen, we want to make sure we're mitigating harm. We're involving the police. We're doing the sufficient notices that are required. We actually have a whole group within Jackson Lewis now, which gives you an indication, a sign of the times. In the last 3 years, this group has formed and been very active and busy and just doing nothing but responding to security threats. And how do you do that? And what's considered secured information that then requires notice to be sent to employees or to customers, et cetera. when this information is compromised. Notifying insurance carriers, all of that stuff, needs to be stuff that you need to take into consideration when you're dealing with these devices. When you're dealing with employee privacy concerns, again, do we have access to a remote wipe? Do we want to require the employee to give us that type of access? Are we truly going to be able to access personal information or contact? How do we put employees' concerns at ease with regards to that? Do they have multiple email accounts? If having access to their personal devices, are we going to have access to medical information, disability information, stuff that's protected by GINA or the ADA? How are we going to make sure we preserve data that may be required in connection with the litigation, especially if an employee leaves us, or let's say their plan even expires and they turn their phone in. A lot of times employees won't even tell you, and you don't know. And so a litigation hold that we thought was effective to protect information and preserve it now is compromised because someone turns the phone in and the phone's never backed up, and we have no mirror copy of it that's been created or stored. And it's now gone, and the employer bears the burden of that, and is the one that ends up with an instruction to the jury saying that the reason the employer got rid of it via the employee was because it had information that was bad. And that may not even be the case. It may just be that we just didn't have a good contingency plan in place. Again, like I said, there are other risks beyond just the privacy concerns and how do you manage those devices. It's really what they're accessing. I mean, we've got employees now that have access to email and to other platforms or intranets where they can perform work off the clock, which creates overtime issues. So you want to make sure you get ahead of that and make sure, you may want to have a distinction between exempt and non-exempt employee usage of these devices and when they can access that. And again, working with your IT department, you may be able to help kind of constrain some of those issues, and perhaps maybe non-exempt employees aren't allowed to access the server after hours. So different things that you might be able to do. Safety, now that you've got an employee who's allowed to use their device at work, who has access to the server and can read email, they're reading email, they get into a car accident. Do we have liability? Well, in Virginia, we definitively do have liability with that type of scenario. Did you cover that in your cell phone usage policy when you wrote that in your handbook? Again, you want to make sure that you're looking at those and encompassing those situations. Union access, if we allow employees to have access that way, unions have absolutely tried to access companies through those types of devices to try and get greater access to employees and to possible voting populations. Employee conduct, do we become liable then for the employee conduct through these personal devices in the workplace? And the answer is absolutely yes. Again, we do. I had a negligent hiring supervision case just in the last year where the employee was inappropriately communicating with a customer, and that becomes a problem, right? Because they're using their personal device. This was a company that didn't necessarily require the employee to use a company phone or a company text platform that they had set up, or their company email. They were a little loosey-goosey and let employees just use whatever was most convenient for them because they were about customer service and customer satisfaction and making sure customers were happy. Well, an employee used it to inappropriately communicate with the customer. Is the employer liable for that type of communication? I mean, obviously we take the position that it's outside the course and scope of their employment and it's not part of their job duties, but that doesn't mean the litigation doesn't come. So you want to make sure that you are anticipating those possible issues. So again, I'm not going to have a lot of time to cover this too much in depth. I just did want to make sure I point out that you are alert to it. In addition, when we're looking at social media for, litigation, generally speaking, the courts are going to require us to preserve a lot of this information for electronic discovery. Electronic discovery rules have become really suffocating in the last few years, and the burden really falls largely to the employer to preserve that information. Because we usually are the ones viewed with deep pockets. And so you want to make sure that you have policies that are looking to preserve that e-discovery. If we have a plaintiff, an employee in the workplace, again, those, extinguishment of expectations of privacy will help us preserve that information and make sure we're keeping that for litigation, a lot of which of that could be very useful to us. Social media has become admissible in courts, generally speaking. courts are looking to let employees use texting and social media posts and emails and other electronic information to establish hostile work environments, to establish retaliation claims. So again, it's just become a very clear extension of the workplace and something that you really do have to make sure you are alert to and aware of. And I've talked really fast to make sure we could cover all the material today. I didn't see any questions come through, but before we get off the line, I want to give you an opportunity to post any questions that you may have.
All right. Well, thank you so much, Kristina. Like she said, we are going to pause for just a moment. If you do have any questions, feel free to enter those now on the chat feature. Otherwise, thank you all for joining us today, and have a good afternoon. Kristina and I are going to stay on the line in case you have any questions.
Someone's asked whether or not we can distribute a copy of the slides from the presentation. Cassie, I can get you a PDF of what I used today, and we can do that.
That would be great. I'll send it out with the survey.
Jan Harbour is asking if she can be made the presenter. I'm guessing she may have a question she wants to ask.
Okay, let's see. I don't see where I can make you the presenter, Jan. I can always unmute you. Jan, are you there? Kristina, I'm not too sure if you could catch any of that. Jan, can you try entering your question into the chat feature for us?
I didn't hear any of it, Cassie. I'm sorry.
That's fine. It was a little inaudible for me as well. I'll try reaching out to her when we get offline, and Kristina, I'll forward you any kind of questions that I get from her.
Sure.
But we are going to go ahead and wrap up for today. Thank you again for all of you for joining us, and thanks again to our presenter, Kristina. Thank you.
Thank you, guys. I appreciate you attending.
All right. Have a good afternoon.